killed the very subsistence of the Rabbit River tribe. Which
what if he had complied with the fines, and he wouldn't be having a contempt order? It's his own. It's the consequence of his own acts.
Yes, Your Honor.
So you're saying that when I'm just going to ignore I'll just go to any tribe and a reservation and what the hell, I'll commit any violation and ignore it. I don't care about the contempt orders. Then what's the use of being allowed to go into any?
Yes, Your Honor. I have 2 points on that issue. So the first is that my client didn't disobey a tribal court order. He simply didn't pay a civil citation. And that had it been a tribal court order, that would have been then therefore he would have been subject to contempt authority in a world where they did have that regulatory authority. But second, and I think most importantly, is that my client has paid the fines as required by the civil contempt order and is still pending stay on this decision as to whether or not he will be detained for 15 days. So you can see that this is how we come under review of ICRA, is that the
Indian Civil Rights Act?
Yes, Your Honor, I apologize. So the civil contempt order was actually criminal in nature, not civil. And that how we decide whether or not it was criminal or civil is whether or not, as Your Honor was saying, he holds the keys to his own prison. That once he complies with the order, his detention is purged. That did not happen in this case. My client has paid the fines, has paid his debt to the tribe, and is still being forced to go to jail for 15 days. So we believe that it is actually criminal in nature, which means that it is subject to review by writ of habeas corpus per section 1303 of the Indian Civil Rights Act.
Is there a writ of habeas corpus in this case?
Yes, Your Honor, we believe that there is. The record isn't clear as to whether or not it was pleaded that way or not, but we believe that his exhaustion in the tribal court saying that they lack jurisdiction over him, but also secondly in the fact in our record, you can see that he challenges his due process challenges are based on ICRA. So we think that it's reasonable to assume there is a writ of habeas corpus, especially when
nobody has, no state or tribal or other entity has custody of his body or his person. So I think jurisdiction should not be habeas; it should be some sort of other jurisdiction. He's not in the penitentiary. You file habeas corpus when somebody's under custody.
Respectfully, Your Honor, my client will be subject to physical coercion to incarceration pending the decision of this court, that it's just on stay.
Let me go back a little bit. Had he paid the fine, had he not paid the fine and he had been there, he would have, for every day he's not paying that fine, he would have perhaps served a day in jail as a civil contempt. Isn't this, for all purposes, a sort of retroactive or a civil contempt penalty? Because we're not talking for these things he's doing on the criminal side. He probably and serving much more time. This is the minimus compared to what anybody can serve as a criminal sanction.
Yes, Your Honor, but we believe that that the mislabeling of the citation was actually critical to the way that my counsel proceeded to be heard in a meaningful manner. That specifically, you can see that the Rabbit River tribe used the label of a civil citation in order to evade due process that was owed to my client. Specifically,
I'm sorry, your client didn't receive due process. Your client was notified of the claim against him, was given an opportunity, was given a very reasonable period of time to pay the fine, and he failed to do that. So due process considerations were complied with. I don't see how there's a violation of due process here.
I respectfully disagree, Your Honor, for 2 reasons. The first reason is that the notice on the citation only gave notice to the deprivation of his property. It did not give him notice to the potential deprivation of his liberty interest. So there was no notice of this impending incarceration, but second, that there was no final hearing before his deprivation of property or liberty.
But, Counselor, that's because he failed to appear.
Yes, Your Honor, he did. No, Your Honor, I don't believe he failed to appear. The citation didn't require him to show up or mandate that he show up within 60 days, but simply said if he wanted to contest the forfeiture of his property, that he could show up within 60 days.
You can see he didn't do anything.
Yes, Your Honor, we can see that he didn't do anything during the 60 days, and the reason why is because he didn't believe that that the court had jurisdiction over him. That whereas if it would have been criminal,
why didn't you file a motion within the 60 days and then try to stay? Because this has been stayed for all purposes of appeals. But he doesn't pay. usually if you were subject to, at least in my court, somebody disagrees. You ask me before the deadline, judge, stay that, or I'll pay the fine subject to any further appeal, but you do it on a timely manner. Your client's not doing it in a timely manner. Why should the court be subject to him managing the court's docket?
Yes, Your Honor. Just to repeat, which is that I think there's a critical difference between the deprivation of his property and the deprivation of his liberty. That he was never given notice that he could potentially lose his liberty. And had that notice been given in the citation, he would have acted differently. And second of all, which...
Counselor, other courts use civil contempt tools. Is there any case law that supports your position that before depriving somebody of their liberty for civil contempt issues, you must give them notice?
Not that I'm aware of, Your Honor, but I do know that in Hicks, on behalf of Freoc versus Freoc, they state that affixed labels to either proceeding of relief imposed are not controlling and will not be allowed to defeat the applicable constitutional protections. So we think the applicable constitutional protections are those outlined in ICRA in section 1302, section C, which specifies 6 or 7 specific procedural due process requirements.
But help me with this. Even if your client was denied due process in tribal court, I don't see how he gets into federal court.
Sure, Your Honor. Let me address the issue of jurisdiction. So first of all, we will readily concede that in the path-marking case of Santa Clara Pueblo versus Martinez, the court grants a large authority to tribal courts and almost a deference to tribal courts to choose. But we think that the Santa Clara Pueblo Martinez case is distinguished on 2 very important levels. The first is that Santa Clara involved a member suing her tribe, that there was not a non-member question of jurisdiction as well. And second of all, in the case of Santa Clara Pueblo, it was a question of whether or not an ordinance was constitutional. There wasn't a question of unjust detention. So we think that the holding in Santa Clara, as read by us, is that it's limited to a writ of habeas corpus. It's limited to the question of detention. And that
why is your first point regarding the political status of your client versus Teresa Martinez and Santa Clara Pueblo, why is that relevant?
Excuse me,
you stated that a way of distinguishing Santa Clara from the instant case is because there you have a member suing her own tribe, whereas here you have a non-member. Why is the political status of the individual important?
Certainly, Your Honor. It's very important because the holding in Santa Clara Pueblo said that ICRA is limited, grants this deference to tribal courts' jurisdiction over their members, that this broad ability to decide what's best and to create statutes, even though they might not ordinarily be held constitutional outside of the tribal context, is because they consent to the tribe that makes those statutes. And in this case, our client did not consent to the statutes and therefore would have no ability, so he had no reason to know that he would be subject to them. So we think that that is a critical issue for the discussion.
But then you're construing a statute here, and in Santa Clara Pueblo, the court says that Congress didn't intend any implied cause of action. You're just habeas, and if you can't satisfy habeas in honoring Congress's intent, don't you have to stay with the restrictions of the statute?
May I answer your question? We believe that there is a writ of habeas corpus, that our petitioner was duped by the mislabeling of the citation, but that he is ultimately questioning the legality of his detention, and that
He's not detained yet. It may be a future detention. He may have a writ of habeas corpus whenever he gets detained. That's when you file the writ of habeas corpus. But you can't file a writ if nobody has possession or control over the body. Right now, he's on bond, but he's not detained.
Yes, Your Honor, it is on an order of state, but the writ of habeas corpus under ICRA has also been extended to members who have been banished from other tribal lands, which is the case at point, is that he's currently not allowed on the Rabbit River tribe.
Okay, let me ask one other question. Just one last question. I know your time's up. There's an agreement between the Rabbit River tribe and your client's tribe to full faith and credit. Doesn't that change in any way the facts in this case or how the law should apply because of that full faith and credit?
We believe that the comedy agreement meant that the Judge Chippewa's order is also illegitimate because the citation under the comedy agreement should have been enforced by a tribal court judge from the LMB tribe. Thank you.